Welcome to Shorthand Hangover, Allahabad High Court APS Series C Exercise 10 at the speed of 100 words per minute. Be ready? Start. The present appeal arises out of the impugned judgment dated 9th October 2019 passed by the High Court of Gujarat at Ahmedabad, in which special civil application number 9536 of 2019 filed by the appellant Inox Renewables Limited appellant against the order dated 25th April 2019 passed by the Commercial Court Ahmedabad was dismissed, holding that the courts at Jaipur, Rajasthan would be the courts in which the Section 34 petition could be filed. Stop para. All the disputes and differences, if any, shall be settled by arbitration in the manner hereinafter provided. Arbitration shall be conducted by 3 arbitrators, one each to be nominated by you and the owner, and third to be appointed as an umpire by both the arbitrators in accordance to the Arbitration and Conciliation Act 1996. In case either party fails to appoint an arbitrator within 60 days after receipt of notice from the other party invoking the arbitration clause, the arbitrator appointed by the party invoking the arbitration clause shall become the sole arbitrator to conduct the arbitration. Stop para. The decisions of the majority of the arbitrators shall be final and binding on both the parties. The arbitrators may, from time to time, with the consent of all the parties, extend the time for making the award. In the event of any of the arbitrators dying, neglecting, resigning, or being unable to act for any reason, it shall be lawfully binding for the party concerned to nominate another arbitrator in place to the outgoing arbitrator. Stop para. The arbitrator shall have full powers to review and slash or revise any decision, opinion, direction, certification, or valuation in accordance with the agreement, and neither party shall be limited in proceedings before such arbitration to the evidence or arguments for the purpose of obtaining the said decision. During settlement of disputes and arbitration proceedings, both parties shall be obliged to carry out their respective obligations under the agreement. In the event of arbitrator's award being not acceptable to either party, the parties shall be free to seek lawful remedies under the law of India, and the jurisdiction for the same shall be courts in the state of Rajasthan. Stop para. There is no controversy as to the constitution of the tribunal between the parties, and the parties have agreed to get their dispute resolved by a sole arbitrator. As per arbitration agreement, the venue of the arbitration was to be Jaipur. However, the parties have mutually agreed, irrespective of a specific clause as to the venue, that the place of the arbitration would be at Ahmedabad and not at Jaipur. The proceedings thus have been conducted at Ahmedabad on constitution of the tribunal by the learned nominee judge of the Honorable High Court of Gujarat. Thus, the concept of judicial seat of the arbitral proceedings and its relationship to the jurisdiction of courts which are then to look into matters relating to the arbitral proceedings, including challenges to arbitral awards, was unclear and had to be developed in accordance with international practice on a case by case basis by this court. Stop. होप यू लाइक द डिक्टेशन। फ्रेंड्स, जो कोई भी मेरा गूगल मीट पे ऑनलाइन क्लास ज्वाइन करना चाहते हैं वो डिस्क्रिप्शन में दिए हुए लिंक के थ्रू क्लास को ज्वाइन कर सकते हैं। थैंक यू।